You receive a summons from the court. What do you need to know when you go to court? Welcome to this segment on victims in criminal litigation. Let us answer your questions. Understanding the summons. When the court starts a criminal trial, they may summon victims or their family members to state their opinions. After receiving the summons, which parts should you pay particular attention to? First, you should note the contact details of the court and the clerk in charge. Once you're at the courthouse, you'll give your case number to court personnel so they can check on your case. As to the case summary, this refers to the type of criminal litigation on the basis of the facts. The time of arrival indicates the time the proceedings are scheduled to begin. Note the location of the proceedings, including the courtroom number, to avoid going to the wrong place on that day. The branch ID is the branch the court has appointed to hear your case. The type of session reveals what the court is prepared to do on the court date. The most common sessions are preliminary proceedings and trial proceedings. When the case comes to court, the preliminary proceedings will begin, and the court will confirm if the defendant has admitted guilt in the answer to the complaint, and whether they have appealed to investigate the investigation evidence. After the preliminary proceedings have concluded, a date will be chosen for the trial, with cross-examinations and oral arguments, where each side will present their case. If the court needs you to present related evidentiary documents, they will list them in the notes section. What should I do if I can't attend court on the designated date? If the summons doesn't say that you must attend court, you can call and ask the court if you can provide a written statement instead. If you're also the complainant, you can hire an agent ad litem to present your statement in court for you. If the court wishes you to attend court in person, you must do so. If you have a valid reason for your absence, you can provide evidence to the court and request a date change. I'm afraid of appearing in court. Will they release my personal information? Don't be concerned. The court will protect the victim's privacy. You may also apply for appropriate devices to prevent being seen by the accused or any attendee. Going to court by myself is scary. Can I get someone to go with me? Of course you can. You can bring a statutory agent, a family member, a trusted friend, or a counselor to court with you. Attached to the court summons will be a notification of your rights so that you can understand your rights in the litigation and the procedures and know what you can request from the prosecutor. People with disabilities can also ask the court for assistance. Preparing for court. The day you are set to appear in court arrives. If the court has agreed to remote proceedings, please refer to the Remote Court Proceedings Handbook in advance. For more information, you can scan the QR code in the top left corner. The courtroom is a solemn place, so if you do attend in person, please take care to dress appropriately to show you take your own rights seriously. On that day, remember to bring the summons, your ROC ID card or other identification, and any documents listed on the summons. Ideally, you should register your attendance at the court early, giving yourself time to find the courtroom. Please make use of public transportation when possible. Don't forget to log in a bit early if it's a remote proceeding. There are 2 ways to register your arrival at court: at the counter or the check-in kiosk. After you have registered and arrived at the appointed court, wait for the court attendant to call you in. If it's not your turn yet, you can either stay outside in the waiting area or sit in the public gallery inside your appointed courtroom and listen to the current session. If the appointed time arrives and your case hasn't been called yet, the previous case may have gone over on time. Like hospital clinics, courts hear several cases every day, so please be patient. You can check the progress of the previous case on the court's website or on the LCD monitors outside the court. After entering the courtroom, please remain silent and be respectful. Court procedures and your rights. Private recordings of sound, images, or photographs are not permitted inside the courtroom. Now I'll take you on a tour of the courtroom. At the front is the judge's bench. Below the judge are the court clerk and the court interpreter. In the center is the witness stand. The victim and the prosecutor are on the right. The accused and their agent ad litem are on the left. Witnesses and other relevant persons are in the spectator gallery waiting to testify. When called upon, enter the seat designated for the victim. Please raise your hand. You may speak with the judge's permission. During the trial, you can request that the prosecutor apply to the court for perpetuation or investigation of evidence to ensure that the evidence is not destroyed, and for the court to verify the veracity of the evidence. In court, you can give your own opinion. During the sentencing process, you can pass your opinion on to the prosecutor to uphold your rights. If the defendant also has civil restitution to make as a result of their crime, the victim can also file an ancillary civil suit at the first or second instance. If the court summons you to appear in court as a witness, you can request an allowance from the court for travel and expenses. If you're dissatisfied with the verdict, you can ask the prosecutor to appeal within 20 days of receiving the verdict. If you and the defendant are both willing, you can apply for mediation or enter the restorative justice process. The court will then arrange the case to be handed over for mediation, or will arrange for a professional organization to get the two parties to engage in a discussion. Hearing the other party reflect on the consequences of their behavior, apologize, and propose a form of restitution can be comforting and healing psychologically for you and your relatives. If you want to find out details of court dates and whether the defendant was granted bail in a timely fashion, you can apply to use the Platform for Victims' Access to Information of Criminal Litigation, and the court will inform you by email. Issues that victims should be aware of during litigation. If the crime involved is of a certain category, you can apply to participate in the litigation. After getting permission from the court, you can enjoy the following privileges. You can choose a lawyer as your agent ad litem to assist in your participation in the case. In addition, Indigenous people or middle to low income households can request that the court appoint a lawyer for free. You may request that your lawyer examine the case archive and exhibits and make transcripts, copies, or photographs of them. The court will inform you of the court dates, and you can choose whether or not to attend. In the preparation stage, you can express your opinion on the proceedings. On the day the verdict is handed down, you can express your opinion on the evidence presented. So, who can apply to participate in the litigation? Any victim may apply. If the victim cannot apply due to illness, death, or limited legal capacity, a statutory agent or family member can apply on their behalf. If you would like to apply, please scan the QR code below to download the application form. Going to court is not as difficult as you might imagine, so let's protect our rights together.